Good afternoon and welcome to the Wednesday Committee on Assembly Health and Human Services. Secretary, will you please call the roll?
Assembly members Dahlia. Here. Edgeworth. Present. Gonzalez. Here. Goulding. Here. Gray. Here. Hafen. Hibbets. Here. Hunt. Here. Jackson. Here. Koenig. Here. Nadeem. Present. Nguyen. Here. Orntlicker. Here. And Chair Brown-May.
Here. Thank you so much. Please mark Assemblymember Hafen absent excused today. Housekeeping items as we begin. Please a reminder to silence your electronic devices. If you wish to testify, sign into the table by the door and provide a business card to our committee secretary. When testifying, we'll ask you to turn on and off your microphone. Clearly state and spell your name for the record. Members of the public may provide public testimony on a bill in person or by telephone. To do so by telephone, you would dial 888-475-4499, and then when prompted, enter the meeting ID, which today is 818-1846-2373, and then press the pound sign. Our meeting agenda is available on Nellis, online, and through our YouTube page. We'll take public comment today at the end of our meeting, and each person will be limited to 2 minutes. As a reminder, please be courteous and respectful in all of our interactions. And please note committee members will be using their laptops or other electronic devices, so please don't take that as a sign of disrespect as they are looking at meeting materials online. Our agenda today, we have 3 bills. We're going to take them in order as they're printed on our agenda. So we will open the bill hearing for Senate Bill 9. And we will welcome our presenters to the table. Thank you so much for being here.
Good afternoon, Chair, Committee Member Stacey Weeks for the record, Division of Healthcare Financing and Policy. In front of you today you have Senate Bill 9. This is a bill that allows the Division of Healthcare Financing and Policy to comply with federal law regarding third-party liability coverage. And I'm going to turn this over to Cynthia Leach, our compliance officer, to walk through the bill and exactly what pieces need to be conformed so we can comply with federal law. Thank you.
Good afternoon, Madam Chair and committee members. My name is Cynthia Leach, and I am the agency manager for the Division of Healthcare Financing and Policy, overseeing compliance and program integrity. We're here to present Senate Bill 9, an act relating to insurance, revising third-party liability, or TPL, provisions for insurers providing coverage to Medicaid eligibles. Medicaid is generally the payer of last resort. When Medicaid beneficiaries have additional health care coverage, third-party liability rules govern the legal obligation of third-party payers. Section 202 of the Federal Consolidated Appropriations Act of 2022 revised 2 requirements concerning the liability of third parties for payment of a health care claim. Provision 1 requires insurers who cover Medicaid eligibles to respond to an inquiry regarding a claim for payment for the provision of any medical item or service no later than 60 days after receiving the inquiry. And Provision 2 requires insurers to not deny a claim submitted by the state agency solely on the basis of lack of prior authorization if the state agency authorized the medical item or service. Authorization by the state means that the item or service an individual received and for which third-party reimbursement is being sought is a covered service or item under the Medicaid state plan for that individual. SB 9 revises existing law to comply with these 2 mandatory provisions and increases Nevada's flexibility to identify and obtain prompt payment from third-party resources that are legally responsible to pay claims primary to Medicaid. Thank you for your consideration, and with that, Chair, we stand for questions.
Wow, that's a record. Thank you. Really well done. Okay. Members, any questions? Again, another record. Okay, I just want to, I'm going to ask you just one, right, because I just want to make sure that we're really clear. And so the one thing that keeps popping up for me is that not later than 60 days after receiving any inquiry by a state agency. So we're really looking to put that 2-month timeline on closure of this billing process, right?
Cynthia Leach, for the record, yes, that's correct. Prompt pay is what we're looking for.
Thank you. And it's specific to only our Medicaid payments.
Cynthia Leach, for the record, yes, that's correct.
Thanks for that double clarification. Okay, I appreciate that. I read the bill correctly. At this time, I will ask you to step back from the table. Do you have a question, Assemblymember Koenig?
Just a sarcastic comment. can we put an amendment in here that Medicaid must reply to providers within 60 days?
I don't think that's germane to the bill, though. Thank you. I do appreciate the question, though. Thank you. All right, ladies, we'll ask you to step back. From this time, we'll take testimony in support of this measure. So if anybody is here would like to offer comments in support of Senate Bill 9, please come forward here in Carson City or in Las Vegas. Seeing none. AVH, is there anyone on the telephone line who would like to offer support for Senate Bill 9?
Chair, the public line is open and working. There are no callers at this time.
Thank you. At this time, we'll move into opposition. If there's anyone here who would like to offer opposition testimony for Senate Bill 9, please come forward in Carson City or in Las Vegas. Seeing none, AVH, is there anyone on the telephone line who would like to offer opposition for Senate Bill 9?
Chair, there are no callers at this time.
Thank you so much. We'll move into neutral testimony at this time. If you would like to offer testimony in neutral on Senate Bill 9, please come forward here in Carson City. Still no movement. Las Vegas, no one there. AVH, is there anyone on the telephone line who would like to offer comment?
No, Chair, there are no callers at this time.
Thank you so much. Would our bill sponsors like closing comments? And we're getting a no confirmation. This is the quickest bill presentation in, thank you for starting us off this way. So we'll close the bill hearing for Senate Bill 9 at this time. Okay, thank you so much. At this time, we'll move to the second item on our agenda. We'll officially open the bill hearing for Senate Bill 187, and we will invite forward Senator Pizzina and whoever else she has presenting. Thank you so much. You may begin whenever you're ready.
Thank you so much, Chair Brown-May, Vice Chair Wynn, and the entire committee on what I'm sure is an exhausting day after an exhausting week of deadlines. Thank you so much for welcoming me here so quickly afterwards. I'm thrilled to be here. My name is Julie Pizzina, and I represent Senate District 12, which covers half Las Vegas, half Henderson, in the southern part of the state. And it's my pleasure to be here today to present Senate Bill 187, which relates to child welfare. For a bit of background, currently there's no shared definition of the phrase best interests of the child across states. In some states, it's defined based on the safety and well-being of the child, access to care, and adequate resources. In other states, the determination's left to the discretion of the courts. And in Nevada, the courts determine the best interests of the child with guidance and insight from investigations conducted by the Division of Child and Family Services of the Department of Health and Human Services. And Senate Bill 187 proposes that child welfare agencies promptly make decisions regarding medical or mental health treatment for children that are within their custody. To briefly walk you through the bill, and it is a shorter bill, Section 2, so really that is most of the bill, provides that agencies providing child welfare services either grant or deny custody for medical or mental health treatment of a child in their custody within 14 days of a request. Additionally, Section 2 requires the agency to make reasonable efforts to initiate such consent and promptly provide notice of the consent or order or the denial or the consent of order. So essentially, just to recap, SB 187 proposes stricter timelines for medical consent decisions for children in agency custody. This came to me from a constituent of mine who has foster children and who has had some challenges getting consent to provide necessary medical treatments. After the conversation with her, I spoke to a number of other Nevadans who've shared similar issues with me, including some who are in this building. So I'm really proud to bring this bill. This has also been the product of what I will say is so much work with stakeholders. There's still more work to be done. Some I found out just moments ago sitting here in this room. So there will definitely be testimony in opposition. I can say, though, in complete good faith that I've been working with everyone. I'll continue to work with everyone, and I'm committed to getting to a place where we can get all stakeholders to be in a good position with this bill. And with that, I am open for any questions.
Thank you for the presentation. We'll start with Assemblymember Koenig.
Thank you, Chair. So the new timeline is you have to respond within 14 days. Is there anything in statute now setting a timeline, or is it wide open at this point?
Right now, my understanding is it's pretty wide open. Some of the families I've spoken with have waited 8, 9, 10 months. And really, that's the challenge. One woman I spoke with has a child who will now have long-term challenges as a result of not being able to get a timely permission to get treatment. And I will also say that I have so much respect for the workers in DCFS who are doing everything they can, and they are heroes who have incredible caseloads. We have another bill that will be coming your way to see if we can increase caseworkers. They're doing an incredible job with what they have, but right now just trying to figure out how to best meet the needs of the children who are in care.
Follow up if I may. So we went from no timeline to 14 days. How did we come up with the 14 days? How did we, not 21 or 28? How did we come to the 14 days?
Oftentimes, if there's a critical need, or I should say if there's a need for, because if there's a critical need, there is action. However, if there's a medically necessary need, it was after talking to a number of the families and seeing where the families came down. That said, I worked with the stakeholders in multiple sessions of 30 plus stakeholders in a room and over Teams trying to figure out where we could be. That was how we ending up where this bill is now. I believe we're still working with SCU and trying to figure out where we can land to ensure that children's needs are met and their healthcare needs, be it physical or mental, are met in a timely fashion.
Thank you. Next, Assemblymember Gray.
Thank you, Madam Chair. Good afternoon, Senator. Maybe I'm looking at this way too simply, but if the child is in the custody of somebody else, why do they have to seek permission to get, shouldn't they have the authority to say, okay, this is medically necessary or not medically necessary to go forth and get this mental health or medical treatment? It seems kind of redundant to have them in somebody's custody, place in somebody's custody, and not be able to make decisions as important as that.
Thank you. And Julie Pizzina for the record. I'm sorry, I think I forgot to do that, Assemblymember Koenig, when I was answering you. Sorry about that. That's a great question. And the challenge right now is twofold. One is if it's a critical need, it can be taken care of. If it's deemed maybe more medically necessary but not critical, then there's the wait. And payment comes into that as well, because if you don't have approval, oftentimes payment can be denied for those services. Some of the families I spoke to spent upwards of thousands of dollars just trying to treat ahead of time without that permission because they didn't feel like they could wait on the authorizations. And for families that are maybe not wealthy who are trying to foster a child, that can be really, really challenging.
Thank you.
Thank you. Next, we have Assemblymember Nadeem.
Thank you so much, Madam Chair. Thank you so much for the presentation. So my question is, if we reduce the timeline from the unlimited to 14 days, which is how it should be. So have you worked with them to how it will happen? We will be needing more providers for that facilities. Any idea how that will go?
Thank you so much for the question, Assemblymember. And should I go through you? Okay, thank you.
Please go direct.
Thank you so much. Julie Pizzina, again, for the record. I think it's less of a healthcare problem, and goodness knows I have so many healthcare bills this session where I've been working on shortages, graduate medical education being one of them. But I think right now it's working with DCFS, working with these amazing, heroic caseworkers who are doing everything in their power and trying to figure out how they can manage that decision-making in a more expedited fashion. That said, we've had many a meeting and we'll continue to have meetings to make sure we land on a time frame that is doable, that also meets the needs of the child. So I think it's probably working with the caseworkers specifically in their processing is going to be the most challenging part.
Thank you. Makes sense.
We'll go back to Assemblymember Koenig.
Thank you, Chair. And Senator, I really do like this bill. I just, is there any penalty or fine or any, anything if it's not met? I didn't see that in there. I was just wondering if that was considered.
Thank you, and Julie Pizzina for the record, and thank you for the question. No, we weren't looking to, again, I have so much respect for all of the work that caseworkers are doing. We're not looking to have anyone face penalties. It's more just trying to figure out how we can work within the system to get these children's healthcare needs met in a more timely fashion. So no, that's not something we were looking at doing.
Thank you. Next question from Assemblymember Vice Chair Nguyen.
Thank you, Chair, and thank you. Welcome, Senator, to the cooler house. I'm kidding. Oh, my bill's gonna get killed in the Senate now. So I want to make sure that we are consistent with the language. And I'm looking at just the amendment. Hopefully, that's the right thing that I'm looking at. I know on certain section on number 2, you reference 3 business days, and then when we were talking about the 14 days, we didn't mention whether it's business days or calendar. Was that intentional, or you gonna want to clarify that as well?
Julie Pizzina for the record. Thank you so much, Vice Chair, for the question. Because 14 days was a longer period of time, honestly, I was looking at 14 days, not including business days, although we're still in discussions to figure out what we can do to make this work out better. We put in the business days for the 3 because we wanted to ensure if something came to them on a Friday, they didn't have to respond by a Monday. We wanted to make it clear it was 3 business days to give them time to appropriately do their job. So that's why we wanted to clarify under the 3 for business days. But that said, there's still ongoing negotiation. So I have a feeling some of these questions will be discussed and the 14 days may move a bit too, as we continue discussions to try to make sure this is something that our caseworkers are able to handle and still meet the needs of the children.
Quick follow-up, Chair. So I just want to make sure I get this on the record because I know I'm working on some of those similar healthcare bills as well this session. So you're probably familiar with some of those discussion as well. But I just want to make sure that we put this on the record that this is a different process. They have to go through this first, then they're going to go through the prior auth, right? Because those are 2 separate processes. This is not one process to get treatment. This is just a consent, and then they'll go into diagnosis, and then they will have to go through a different wait time for the prior auth to kick in.
Yes, thank you. Julie Pizzina again for the record. And yes, that is correct.
Okay, great. I just want to make sure that's on. Thank you, Chair.
Next question from Assemblymember Gonzalez.
Thank you, Chair. Good morning, Senators. I just looked down and looked up, and another one popped up. That was fast. Hello, good afternoon. So my question is Section 2, subsection 3, A and B. So first it says that we have this 14-day timeline, and then it says after that, subsection B, that we have to notify the person or entity with whom the child is placed within 3 business days. So how do those timelines work together? And I'm sorry if we already went over that. I'm just still a little confused.
No, thank you so much, Julie Pizzina, for the record, and I'm so happy to be joined by my colleague, Rochelle Wynn from Senate District 3, who represents Las Vegas in the southern part of Nevada. So once the Child Welfare Agency is made aware that the child needs physical, mental health care that's necessary for their well-being, then after that time, they have 14 days to get approval, to find out it's been denied, to figure out what the answer to that need has been met. And again, as I said, we're still definitely working with all parties, so that 14 days may change. But once that has happened, then after that 14 days, they have 3 business days to notify. So it's kind of 17 days, I guess, if you look at it that way. So 14 days to get an answer, and then 3 days to provide the answer.
Thank you so much. And then my next question is, what happens in the event that it is denied?
Rochelle Wynn for the record, and I apologize that I was late. I was coming from Senate Judiciary where we were hearing assembly bills. So in the case that it's denied, I think there is the procedure that there's an appellate procedure like that's in place already through this process. I know there are people in the room that are much more equipped to be able to answer that question. I think the intent of this was to make sure that these children that have either foster parents that want to be able to get them the care that they aren't held in like a legal limbo when they are trying to provide those services. But I think there are probably people that are equipped to answer that question better in the room. And so with the chair's permission, I'm sure when they come up to either testify in support, opposition, or neutral, they might be able to answer those.
Thank you. I do have a question. I just want to spend a little bit of time and let's get some of this on the record, right? And we're talking about if an agency which provides child welfare services, right? What are those agencies?
Thank you, Chair. Julie Pizzina for the record. So in Clark County, we have the Division of Children and Family Services, who is handling a lot of foster care children. Washoe, of course, is doing a great job, as well as are a number of other agencies throughout the state. And admittedly, right now, I think they're doing, and I've said this before, they're doing a wonderful job with what they have. They need more caseworkers. But those are some of the services in question.
Thank you. And are we also including private care agencies that potentially would have contracts through the counties to provide services for these youth?
Julie Pizzina for the record. No, I was not looking at those in this, but that's a great, as we continue to work further on this bill, that's a really good point, because when those children are in that custody, we obviously want to make sure that their physical and mental health care needs are met.
Thank you. I appreciate that clarification. I just want to make sure we don't inadvertently leave out an agency or haven't considered one as we move forward. Then can you talk a little bit about where does the child advocate, like we have the CASA program, like have you thought about where child advocates would play into this regulation?
Julie Pizzina for the record. So child advocates have a really important part of this process. They work closely with a lot of the foster families that have children who have these needs. I think right now, unfortunately, they haven't been able to get those medical needs provided, and that's why we came up with this. At least with a number of the families I spoke with, I know that their CASAs were really engaged and really wanted to help. They just weren't able to make this happen, and that's part of the reason we came up with this SB 187.
Rochelle Wynn for the record. May I follow up with that as well, Chair? I think there was a desire, and I think there has been conversations that are continuously ongoing with the counties. I know that there was some indication that they wanted to include people like the CAP attorneys or the parents or other some of these outside agencies, and subject them to the same motions and timelines that are in here. I think it's kind of our understanding, and I think maybe, I don't know if Mr. Norman is in here from Legal Aid, but I think they would probably concur that as we read the statute as it is written, if there is a medical need, the department as the custodian, so those two major agencies would have the obligation to file for this. And again, I think the intention and the intent behind this is just to make sure that we both actually have had constituents that have been in this situation where they're fostering kids. They want to be able to get them the mental health treatment, the physical treatment that they need, and they believe that they are that these children need, and they are running up against roadblocks where they're not able to do that in a timely fashion. And so this gives some guardrails to make sure that these kids aren't left behind, especially when they have foster parents that are so willing and are able to identify some of those things early on.
Thank you. I appreciate the clarification. Members, any other questions? Okay, seeing none, thank you so much. We'll ask you to step back at this time. We will open up testimony in support. If you are here in support of Senate Bill 187, please come forward at this time here in Carson City or in Las Vegas. Seeing no one moving, AVH, is there anyone on the telephone line who would like to offer support for Senate Bill 187 at this time?
Chair, the public line is open and working. There are no callers at this time.
Thank you, AVH. At this time, we'll move into opposition testimony. If you would like to offer testimony in opposition of Senate Bill 187, please come forward at this time. Fill in the chairs. State and spell your name for the record. You'll have 2 minutes. You may begin whenever you're ready.
My name is Aisha Goins, AESHAGOINS, and I am here on behalf of SEIU. And we are opposing this bill. Michelle Mayesse, who is the president of SEIU, has sent me her words. She has been in Department of Family Services for 17 years. She's a supervisor of the Clark County Family Services. She's on a plane, so she sent me text. if the child needs treatment within 30 days, foster parents and the department will make the best effort to get in touch with natural parents. We support that process. We do not support anyone making decisions for a child because they can't get a hold of a parent for 5 days. Again, if it's medical necessary, the doctor will do surgery. Our goal at Family Services is to have safe children and healthy families that include the great foster parents that we have and that we partner with. Our parents try to make the best homes appropriate for their kids when possible. I just want to put on the record that the concern is the natural parents and their ability to say yes or no. And oftentimes it takes time to reach the natural parents, and this is oftentimes the problem in the timeline of getting care. Also, there have been some issues with religious practices and things of that sort. And so we want to just ensure that the natural parents aren't losing their rights in this time process. Thank you.
Good afternoon, Chair Brown May, members of the committee. For the record, my name is Cadence Matijevich, Cadence representing Washoe County. And Madam Chair, I want to start first by thanking Senator Pazina. She's right. She's worked incredibly hard on this bill and has been very, very open from the start to hearing concerns that various stakeholders, including Washoe County, had with the original version of the bill. And really at this point, I think we're down to a pretty technical piece, and really it's in section 2, subsection 3A, where it talks about becoming aware of the need. And for us, we don't see that there's a definition of need, and there's been a great deal of conversation here today about medically necessary procedures. But there are other times when there are procedures that in the position of the Child Welfare Agency could be elective procedures. And we want to be sure that we are not in those cases compelled to take this action where we don't necessarily believe that there is that need. I will say that we can do and will initiate the orders when they are necessary, and we're not disputing that. But there are times, if a kid needs to undergo general anesthesia, something like that, where we do need to get a court order, and we'll do that. There are some other elective procedures. You heard Ms. Goins say maybe there's a dispute between what the biological parent thinks is a necessary procedure and the foster parent thinks is a necessary procedure. And in those cases where there's not agreement and we don't believe that it's necessary, we want to be sure that this bill doesn't compel us to take that action, and that if in fact that biological parent wants to take the action to seek a court order, that they're not prevented from doing so by the language in this bill. We will continue to work with the senator on it, and thank you for hearing our concerns.
Good afternoon, Chair Brown May, members of the committee, Joanna Jacob, on behalf of Clark County. As you will, over the next couple of days, you will see that I will often concur with the comments with my colleague from Washoe County or her with mine. We have been working together on a number of child welfare bills that are headed your way. And so I'll concur with her comments, echo the comments about working with Senator Pazina and also Senator Wynn, who have been trying to work with us on this bill. We understand the concerns of the foster parents, and we honor our foster parents, and we want to try and make it easier for them to work with the county. One of the things I want to make clear, though, in the discussion on this bill is that the Child Welfare Agency that is referenced in the bill right now is currently the counties. It's Washoe County, Clark County, and the state that covers all of the other areas and counties. The second thing is that when we are dealing with routine medical care, as Ms. Goins mentioned, the order that places the child into our custody covers the ability for us to deliver routine medical care. So I want to make sure the committee understands that we are not denying routine medical care for our kids who are in our custody, and that is frequently something that does come up, as Ms. Matijevich noted, where we have more invasive procedures, where, as Ms. Goins noted, sometimes it is difficult for us to get in touch with the biological parents, and they are still legally a party to the case. And we have to try and honor those consents, and it does take time. That is one of the things that we have been struggling with and trying to find a way to get through this, knowing that this this issue of the timeliness of our orders and the communication is one thing that Senator Pizzina and Senator Wynn have wanted to tackle. So we are almost there. I will say with Ms. Mativich, it's a technical issue. We'll continue to work with the senators on this. And really one of the things that we would like to talk about is when we become aware of the need of the treatment and just make it more flexible so that we're not taking on a duty beyond where we already do. And we are trying to deal with really what we see as elective procedures. Thank you.
Thank you. Right at 2 minutes. Really well done. Is there anyone else who would like to offer testimony in opposition of this measure here in Carson City or in Las Vegas? Seeing none, at this time we'll move into neutral testimony. If you'd like to offer testimony in neutral, please come forward at this time. Thank you. Mr. Norman, state and spell your name for the record. You may begin.
Chair, members, Go ahead. Chair, as a member of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. So we represent direct representation, which means we follow the wishes of our clients, kids in foster care. We appreciate Senator Pizzina working on this bill. We did a lot of work in the first house to get to where it is today, so we appreciate all those stakeholder meetings. I do want to point out that I don't think anything in here prohibits a CAP attorney or a parent's attorney from filing a motion on behalf of their client for elective medical care. And I'll give you an example, would be cochlear implants. We have had to file motions because a parent didn't want their child to have cochlear implants because they wanted them to be part of the deaf community. So we had to file a motion and litigate that case to the Nevada Supreme Court. Those are cases, and I don't think this changes that structure. And when we think about consent, to Assemblymember Gray's question, the reason we have this is because a parent maintains their parental rights, so they have to be consulted and consent on medical care that is of a serious nature, so not like routine medical care, and I think that's important. So if you follow this, you try to get, in subsection 2, you try to get consent from the parent. If you can't, then you have to go to the court. In situations where we would go to the court, or is appropriate for the department, is general anesthesia that's non-emergency, so non-life-saving. And you can think of that if a young child has 27 cavities and is of a certain age, they're going to need general anesthesia for that procedure. That's very common, not super common, but it is common enough that it comes up every year in multiple cases. You would need to go to the court to get that court order for general anesthesia. The cochlear implant's another example. So I don't think anything in here stops a CAP attorney or a parent's attorney from filing a motion. And I want to make that clear because we always have the right, client-directed, to file a motion on behalf of our clients. And then just teasing out like emergency versus non-emergency. The dentist is non-emergency, 27 cavities. We need to get consent and potentially a court order if a parent won't. So thank you so much.
Thank you for that. Is there anyone else here in Carson City or in Las Vegas like to offer testimony in neutral on this measure? Seeing none, AVH. Is there anyone on the telephone line who would like to offer, and I believe I skipped over opposition testimony. So is there anyone on the telephone line who would like to offer testimony in opposition or neutral at this time, AVH?
Chair, the public line is open and working. There are no callers to testify at this time.
Thank you so much. At this time, we'll call our bill sponsors back up if you would like to make closing comments.
Julie Pizzina again for the record. And the first thing I'd like to say is thank you all so much for hearing this bill today. It was brought by constituents, and Senator Wynn was kind enough to come up with me because she also has constituents who face similar issues. And we have really enjoyed and we really appreciate all the testimony today, be it in neutral, be it in opposition, because it's so important. And we've been working with these same stakeholders now for a good period of time, and we can look forward to continuing to do so. And we will get all updates to the committee. And with that, I'm going to hand it over to Senator Wynn.
Rochelle Wynn for the record. I just wanted to talk about this. I know that in the opposition testimony, it was indicated, this is the first time we're learning that a CIU was in opposition. I think during the Senate hearing, they actually came in support. So we will have engaged in some of those other conversations. But I know that there was mention not having enough time within 5 days to engage with natural parents. I don't think there's anything in this bill, in either the amended language or what's presented before this committee today, that indicates that there's any 5-day timeline. It looks like in all cases there is a 14-day timeline. And we have that. And I think you heard briefly a little bit about some of the concerns on whether or not something was medically necessary versus elective surgery. I would argue that 27 cavities is a medical necessity. I think those are some of the things that some of the parents that we have, foster parents that we have communicated with, are really struggling, where things that are not considered routine care and that are not medically necessary fall into those. One of the examples that I was given that really motivated me in this situation had to do with a foster parent who had a newborn child, that when they became guardians of that newborn child temporarily under the foster care system, had been so neglected that needed one of those child helmets because their head was so misshapen from the neglect during a crucial time period in the first months of that child's birth. But that was not medically necessary, and that was considered an elective procedure. And so that parent felt like it was a medical necessity and it was taking too long and never got the approval, and ultimately paid cash for that kind of helmet to have so that child wouldn't have further ongoing developmental issues. And so it's things like that. I mean, hearing that 27 cavities is not medically necessary is pretty shocking to me, especially for anyone that knows that dental care is so tied to all of these other things. And it makes me wonder what other things are not medically necessary that are considered elective procedures, that we don't have that engagement. Obviously, we want to make sure that we engage parents, natural parents, through this situation, but there should be some timelines to ensure that they are. I know things like therapy, and I know things like physical therapy, occupational therapy, speech therapy. Those are probably not medically necessary. And I think in this committee, unlike other committees, you see the effects when things like this are neglected, how they, find their way in our school system. If you don't get a cleft palate surgery when you are an infant, and that might be something that's not medically necessary, you may have 5 surgeries if you start it at infancy, but if you don't, you're going to have speech therapy, you're going to have developmental issues into adulthood if you wait until you're older to take care of some of those things. So those are some of the intent that we are looking in bringing a Senate Bill 187. And sorry, I know that was a very long closing argument, but we will continue to work with stakeholders.
Thank you. Thanks for your closing argument. We'll officially close the bill hearing for Senate Bill 187. Thank you. Okay, that leads us to the last item, or the third item on our agenda. Sorry, we're not our last yet. And we will open the bill hearing for Senate Bill 349, and we will welcome back Senator Pezzina.
Thank you so much again. Hopefully you're not tired of me after the last bill hearing. Once again, my name is Julie Pezzina, and thank you so much to Chair Brown-May, Vice Chair Wynn, the entire Health and Human Services Committee for seeing me after an exhausting week. I'm back again, this time to present Senate Bill 349, which revises provisions relating to anatomical gifts, and I'm joined here by a representative of Nevada Donor Network, Dan Musgrove, who will be speaking momentarily. Just to give you a small bit of background before I turn it over to him, I think there's some important things to note coming into this particular bill, which I hadn't known and was so happy to be working with the Nevada Donor Network on this bill. According to an investigation from Kaiser Health Foundation between 2014 and 2019, roughly 170 organs could not be transplanted, and almost 370 were near misses due to delays from transportation issues. With over 113,000 people on wait lists, desperately waiting for a life-changing organ, there are many missed opportunities due to these transportation wait times. And that's something I'd like you to just keep in mind during the presentation. To give you a brief summary, Section 1 allows for a procurement organization to transport or arrange for the transportation of the body or part of a registered or authorized donor when medical equipment is required to preserve or increase viability of donation in accordance with Chapter 451 of Nevada Revised Statutes. This bill is really here to save lives. And I'm so fortunate to partner up with the Nevada Donor Network on this bill. And at this point, I'd like to hand it over to Mr. Musgrove.
Thank you, Senator Pizzina, Chair Brown May, Dan Musgrove with Strategies 360 Today, happily representing Nevada Donor Network. It seems like months and months ago, but if you remember back on March 5th, we came in front of you and talked about our mission for the state. And I promise Dr. Momenti is in the building. He's in Commerce and Labor. He left. I wanted to make sure he did not come and tell our marvelous chair how to run our meeting. So I'm here. Thank you. Yes, if you remember that eventful day. But SB 349 is, to the senator's point, we have a mission at Nevada Donor Network, which is to save and heal lives through organ donation, eye and tissue donation. And we accomplish that two ways. One is to cajole and ask Nevadans to check that box at the DMV or volunteer to become organ donors. And believe me, that is an important mission in and of itself. But the second thing that we do is we work very, very hard to make sure that we have the ability to procure and provide for transplantation viable organs, tissue, and eyes. And there are times when the clock is ticking. We have a very finite time in which to procure those organs and make sure that they can be transported. And the law was a bit silent, and we have an excellent partnership with our funeral and mortuaries throughout the state, and they have been our partners in this transportation. One of the things that happens right now is that we procure that organ in a hospital, and we are at the mercy of the hospital to use their surgical suites to get those organs. And one of the things that Nevada Donor Network is doing that other organ procurement agencies have done across the country is create our own donor care unit where we have a facility, much like a hospital operating room, where we can move that deceased, that loved one who has made the gift of life, to that facility and begin that procurement. But there may be a time when that deceased needs medical equipment to ensure that the organs remain viable. That's what this bill clarifies in statute, that if under that very narrow circumstance, we have the ability to transport ourselves. And we would do that using an ambulance, an ALS, a BLS, which is regulated by the state. We would do everything to, again, make sure that that organ donor is treated with respect and dignity and kept viable so that they can give the gift of life to anywhere between 8 and 80 people that may reap the benefits of their gift of life. So the second half of the bill is just that we work in partnership with the coroners in the state. There may be an instance where that deceased is a part of a criminal case. And so we just want to make sure that they have the ability to provide for a method in which we would make sure that we are working in conjunction with them and have notified them that we're ready to transport if they are in fact ready to release the body to us. That's all the bill does. Two sections. One gives us the ability to transport using specific medical equipment. The second, to make sure that we notify the coroners at their request. And we stand open for questions.
Thank you for your presentation. We'll start with Assemblymember Gray.
Thank you, Madam Chair. Mr. Musgrave, question for you. Why use an ambulance or medical transport? Why not just use like or have the mortuary meet you guys at the hospital? They have vans that are very they don't stand out, and they usually have pretty good response times. Or have somebody from Donor Network pick up in a non-emergent vehicle. I mean, it seems like a pretty massive resource to take out when you're not really going to be saving a whole lot of time, even if you're running code. But I don't think you're even allowed to run code, are you, for transplants?
Dan Musgrove, in answer to your question, and I know we have the folks behind us from the funeral and mortuaries, They don't have that kind of equipment, nor do they want to enter into that type of situation, and that's why we were very specific. And this has been a partnership with them we went to them and said, what is the way in which we can do this? And believe me, they have been great partners, but there are moments in time when they are unable to transport. It's very rare, but we don't ever want that occasion to pass. And to your point, at some point, we will probably have our own equipment. We just wanted to make sure that this allows for us to use a bus, an ambulance, or whatever that has that specific medical support equipment that we need on board. But yeah, once we get the donor care unit on, it would be our intent probably to have our own equipment, and it would be unmarked, and there's no reason to move code. It really is just keeping the body in a situation where we can get those viable organs, and so that they don't somehow, go to waste, very candidly. Hope that answers your question, sir.
Okay, so when you're talking about equipment for transport, I was thinking you were just transporting the body. So I'm assuming you're talking life support equipment that it's just going to, keep them breathe, keep the lungs and the heart and everything going, even though that's not a viable person at that point. Or so when I'm thinking transport for donor, usually it's just unfortunately it's just the body in a body bag in the back of the van with the sheet over it.
Dan Musgrove, yes, it would be really just probably a ventilator to keep all of the organs functioning. There's two ways to be declared dead: your heart stops, or you're brain dead. And this is usually an occasion when the person has been declared brain dead, and so that we can keep the rest of the organs viable for transport. And so that's when we would need that equipment.
So even with a ventilator, the ventilator isn't going to do anything if there's no cardiac activity. So would you guys be using a thumper or something along those lines? It sounds like it'd be a full, life support system. You've got to get the air into the lungs or the oxygen in the lungs, and then the lungs have got to transport through the body to keep those organs viable. So I'm just kind of not following the process here. The ones I've been involved in haven't been that complicated. So just clarify.
Madam Chair, Dan Musgrove, I think you've gone beyond my expertise. I will ask perhaps the funeral home folks if they can help clarify, but if not, sir, I will get you that answer. But again, we really just wanted it to be general enough to allow for whatever transport might be needed because normally we would do it in a hospital and everything is there, but if and when we get to the point where we have a donor care unit and it makes sense for us to transport to that facility, we just want to be able to transport and make sure that everything's viable.
Thank you. Next question from Assemblymember Nadeem.
Thank you so much, Madam Chair. Thank you for the presentation. I'm very much interested in knowing what kind of transportation you have. Is that a private ambulance? What kind of facility that you have?
Dan Musgrove, right now we don't have anything because we're looking to get this statute passed. Right now, it's rare that bodies are transported away from a hospital. When all of that is taking place at the hospital, funeral homes will still bring us the deceased for, let's say, tissue and removal and that kind of stuff, procurement. But right now, it all is taking place in a hospital situation, so there really isn't a need for that kind of transport yet.
Okay, so that is for the future after this.
Absolutely. We're just trying to make sure that we don't have any stumbling blocks as we move forward, and again, trying to make sure that we have the ability to go after every viable organ that we possibly can get.
Thank you.
Thank you. Members, any other questions? Okay, seeing none, thank you so much for your presentation. We'll ask you to step back. At this time, we'll open up testimony in support of Assembly Bill 349. If you're here in support of this measure, please come forward. You'll have 2 minutes. State and spell your name for the record. You may begin when you're ready.
Thank you, Chair, members of the committee. Warren Hardy, today representing La Paloma Funeral Services and Life Science Anatomical. We're in full support of this bill. We appreciate Mr. Musgrove, who reached out to us last fall. We also appreciate Chair Pezzina for her willingness to hear our concerns. This really is, I think, going to Mr. Gray's question, this really is an opportunity to up our game a little bit in terms of having Nevada Donor Network being able to have a facility to perform these types of things and make the organs more viable. Currently, they're just, as I understand it, they're done in a hospital. They're at the mercy of the hospital room. It'll be much more effective and efficient once they get their facility to be able to take these bodies. We won't do it. We did have concerns initially because there's probably not enough regulation over picking up a decedent. And so we are always concerned when that gets expanded. But this very narrow set of circumstances, we would not have the ability to we would add nothing of value to the viability of the decedent. So we're in support of the bill, and we think it's a good bill at this point. Thank you.
Good afternoon, Jennifer Lazovich, Lazovich, here today on behalf of Davis Funeral Home. We too are in support of the bill. We want to thank the sponsors, particularly Dan and Nevada Donor Network, for working with us before they brought the bill. We sat down and very collaboratively talked about what our concerns were, what their purpose was for the bill, and we came to language that worked out great, so we appreciate that very much. Thank you.
Hi, good afternoon, Chair and members of the committee. For the record, Trevor Parrish with the Vegas Chamber. The Chamber's in support of this bill, as this will help streamline the organ donation process. When healthcare professionals handle these anatomical gifts, every minute matters for the patient. And SB 349 will help save lives by allowing procurement organizations to act quickly in that crucial time frame. Thank you for your consideration.
Thank you, Chair and members of the committee. Blaine Osborne, Nevada Rural Hospital Partners, for the record. In another hat that I get to wear, I get the honor to be a board member for Nevada Donor Network. And so I think this is a fantastic bill that is going to help support increasing organ donation in the state. Really appreciate the committee's consideration. Thank you.
Hello, good afternoon, Chair Brown May, Vice Chair Nguyen, my members of the Assembly. Health Human Services Committee, my name is Devin Ashoff, DEVENASCHOFF, up here on behalf of Torrey University, Nevada. Just wanted to say that we are in support of SB 349, and we thank Senator Pezina for bringing this bill forward. Thank you.
Thank you. Seeing no one else here in Carson City in support, no one in Las Vegas. AVH, is there anyone on the telephone line who would like to offer testimony in support of Senate Bill 349?
Chair, the public line is open and working. There are no callers at this time.
Thank you. This time we'll move into opposition testimony. If you are here and would like to offer testimony in opposition of Senate Bill 349, please come forward. Seeing no movement here in Carson City and none in Las Vegas, AVH, is there anyone on the telephone line who would like to offer testimony in opposition of Senate Bill 349?
The public line is open and working. There are no callers at this time.
Thank you, AVH. At this time, we'll move into neutral testimony. If you would like to offer testimony in neutral on Senate Bill 349, please come forward. No movement here in Carson City, none in Las Vegas. We'll check one more time. AVH, is there anyone on the telephone line who would like to offer testimony in neutral on this measure?
Chair, the public line is open and working. There are no callers at this time.
Thank you, AVH. At this time, we'll call the bill sponsor back up. If you'd like closing comments, we're getting a no. That officially closes our bill hearing for Senate Bill 349. Thank you so much for being here. Okay, that moves us to the last item on our agenda, members. It's time for public comment. We are open up time for public comment. If you would like to, you are welcome to come forward at this time. Seeing no one who would like to offer public comment here in Carson City, no one in Las Vegas. AVH, is there anyone on the telephone line who would like to offer public comment?
Chair, the public line is open and working, and there are no callers at this time.
Thank you, AVH. Members, that concludes our business for today. We will meet again on Friday. Please note the time change for our committee meeting. We do have 3 bills on our agenda for Friday. With that, we are adjourned.